Today is July 17, 2007. We're at the Sheraton Waikiki Hotel in Honolulu, probably the best place to do an interview like this.
I can't think of a lot better places we could be.
I'm fortunate enough to be sitting across from Judge Lowell Jensen. We're going to do a brief video interview which will supplement what I expect will be a much longer audio oral history taken sometime later this year. I am Bill Edlund, and we're doing this on behalf of the 9th Judicial Circuit Historical Society. And I feel very privileged to be interviewing Lowell.
I feel privileged that you were doing it.
We go back a lot of years.
We do.
Well, we knew each other in law school, didn't as an undergraduate. Maybe you could tell me what brought you into a decision to go to law school?
Well, it's a good question with no answer, because it's just one of those things. It was clear to me that I was going to go to law school, and when I went to Cal, I got into so-called pre-law, and I intended to go to school, but I don't know why I made that decision. I didn't have family members or role models or sort of things leading me into law, but somehow I had made the decision that that's where I wanted to go. So I was preparing for law school and fortunate enough to actually be admitted.
At law school, were there any of the professors there that you found particularly enjoyable or not enjoyable?
Oh, I think they were fine. Dean Prosser was there at the time, Bill Prosser, the legendary torts professor, and I had him for torts, and he was just marvelous. And Ed Barrett for constitutional law, and Bill Lawby was contracts, and Dick Jennings was there. So we had fine faculty, and it was a good time.
I know that you subsequently went on to practice criminally on the criminal side in prosecution. Was there anything during law school that led you to that?
No, as a matter of fact, it was sort of contraindicated, I guess, because Captain Kidd had been the criminal law professor at Bolt for years and years, and he left the year before I got there. So when I got there, the criminal law teacher was someone had just been brought in and wasn't going to stay there for very long. And I have to say, he wasn't one of the stars on the faculty.
Not a favorite.
Not at all. No, he was fine, but we didn't really have a good criminal law class. I don't think so. So that didn't have any kind of effect upon my ultimate career.
Well, you went into the military. You were in Korea, and you came back.
Well, what happened was I got drafted. I mean, those were the days when you got drafted, and they let me stay out until I took the bar. When I took the bar, then the next week I was in the Army. And my Army career was short, brief. It was fine. They have these programs where you can go into the JAG and that sort of thing. Well, they were closed, and I hadn't passed the bar at that point. So I waited until I had passed the bar and then looked at it. And they said, if you're going to sign up, you're going to have to sign up for 3 years. And so I wasn't interested in signing up for 3 years. So I completed my tour of duty in the Signal Corps. And I was stationed here on the West Coast. I was a cryptographic specialist. I didn't know how to break codes, but they told me how to do them. So I did cryptography. And I was here actually stationed at Presidio in San Francisco, and then I was sent to Tokyo. So that was my Army career.
Well, good duty.
It was fine. Yeah, no problem. The only problem is Barbara couldn't go because they didn't allow corporals to bring their spouses to Japan. So that didn't work out very well.
You came back. You stayed in the Bay Area.
Did.
What happened next?
Next thing that happened when I got back, I looked for a job. I didn't get attached to any law firm. I was looking around, and one of the first places I looked was to the Alameda County District Attorney's office. And I was fortunate enough to get hired there. So I got hired there in the end of '54 and started in as a deputy in 1955, and then stayed there. My basic career started right there, and I stayed in the DA's office until 1981.
Unlike the present time when many of the young lawyers are peripatetic and
Correct.
go from office to office, you were there the entire time.
Well, there was, things changed when I was there. You didn't stay there. It wasn't expected that you would stay there. You would go there for maybe 2 or 3 years, learn how to try cases, and then you could go into the profession. And law firms would like to hire people like that because you don't get litigation kinds of practices like that. So I had opportunities, I think, to leave and to go into private practice, but the timing never seemed to be right, and I just stayed. And I enjoyed being a trial lawyer in the office, and then things broke so that I got a chance to be appointed the district attorney. And so 1969, I became the district attorney, and so then I stayed there as the district attorney until 1981. Excuse me, 80. Yeah, no, 81, that's right.
Early practice with the district attorney's
Right.
office. How did it work? That's when Coakley was
Frank
the
Coakley
DA.
was the DA, right.
Yeah.
Frank Coakley, legendary DA, wonderful, wonderful man.
You worked directly under Frank.
I worked directly under Frank. Office had about 50 people in it then. And
50
half of
people, attorneys, or 50
No,
total
50
headcount?
attorneys, but maybe 15 to 20 of them did civil work, because at that time the DA's office did the civil work, and there was no county council, and so the county council was created while I was still there. But you would move on, and when I first came in, you could have private practice. As a deputy district attorney, you could have conflict-free private practice, and there were some people who did that. And if you had a lot of probate clients or something like that, you could do that. But I didn't have anything like that. But it changed, and they took away private practice, and they gave you more money. So there was more of an impetus to stay for careers, and that's why I stayed, among other things.
What kind of cases did you get when you first went?
When I first went, I was trying drunk driving cases, petty theft cases, just the basic misdemeanor things. But you learned how to try cases. I mean, you had a lot of cases, and so it was a great learning experience. There was one occasion, I think, where Stephanie Bryan was a young girl who was kidnapped in Berkeley and then taken up to Trinity.
That case got a lot of publicity.
Burton Abbott was the case, and I was there at the time, but I was working in Oakland in the municipal court, and Frank Coakley tried the case, and he brought all the talent sort of up to support him, and he left just a couple of people. So I was left in Oakland with John Sutter, who later became a Superior Court judge, and the two of us tried all the cases there. So we tried maybe 3 or 4 trials a week for about a couple of months. So we tried an awful lot of cases.
How do you prepare for 3 or 4 cases a week?
No, you just you get the file, and when the judge says, "Are you ready?" you say, "I'm ready, Your Honor," and you hope that you were, and that the witnesses would come in and they would say what the report said, and so you got them prepared basically and tried them. But you could try a misdemeanor case then in a day. We could pick a jury and complete the case, argue it, and get a verdict by the end of the day. That's not possible nowadays. You can't do that. Mm-hmm. But we did.
When you took on greater responsibilities in the office, deputy DA, were you still trying cases then?
No, I tried cases. And the way it works, you spend a couple of years in the muni courts, and you tried misdemeanor cases, and you presented the felony preliminary examinations, and then after that they took you up to the Superior Court, which is where the felonies were tried. And so I became part of the felony trial staff, and ultimately became the head of the trial staff there. And so I had a lot of very interesting and sort of noteworthy cases. I tried Huey Newton.
Tell us about that. I remember reading about it.
Black Panthers grew up in Oakland. They got started in various things, but one of the things was an incident that happened in West Oakland where Oakland police stopped, and there was a confrontation with Huey Newton. There was a shooting, and Newton killed one of the police officers, and another officer was shot, and Newton was shot, and so ultimately I tried the case.
You first chaired it. This wasn't
No, I tried it. I was the only lawyer who tried it, And it was the courthouse was surrounded by people who were walking around the courthouse, and in those days you didn't have anything like metal detectors. Everything came into the courthouse, and it was a relatively tense time. So that took a couple months, tried, and he was convicted of manslaughter. Went up on appeal, came back. They reversed it because of some jury instructions that we'd agreed to, but then the Court of Appeals felt that that should not have been agreed to, and so they reversed it. And
who was your trial judge, remember?
This is part of the moments. I know who it is, but and I'll think about it as we go along. Right.
Did you try any other cases that had that kind of visibility? Huey
Well,
Newton's
I think
trial,
so. Huey's big trial. And then I tried the free speech movement case at Cal. They had the sit-in at Berkeley. We tried. There was about 750 people arrested.
How did you try 750 people?
Well, we didn't. See, you could have a jury trial, and we set it up so we'd have a whole sequence of jury trials from a prosecution standpoint. We knew we'd have to bring in other judges, and we couldn't try them all at the same time, so you just had to try them sequentially, and so we got it set up that way. And then we had some discussions with the defense counsel, and the agreement was that we would have a single trial, and it would be a court trial, and it would be such that both sides could pick people that they thought should be representative and be part of the trial. So we ultimately ended up trying 155 of the defendants in a single trial.
Before a judge?
Before a judge. Rube Crittenden was the judge, and the judge before was Monroe Friedman, the judge who tried Huey Newton. But this was before Rube Crittenden, and we spent about 3 months trying 155 people in one case. And ultimately ended up we finished that case, and then we had an agreement with the defense that we would stipulate as to the great bulk of the rest of them, where we would put in our case by declarations and show everything that had happened. And then the defendant could file anything they wanted to, including a statement as to why they were there. And so all those cases were submitted to the judge, and then one day the judge found about 600 people guilty. And that basically took care of the prosecutions in the case. But that was another major case, I guess. So,
how did you avoid possible constitutional arguments?
There were constitutional arguments. Yeah? No, there were direct constitutional arguments, and the argument basically was, the whole area of speech, and the question is time, place, and manner of the speech, and our position was you don't get to choose that, and when they had taken over a building and prevented its use for the university, there was a trespass, and so it was tried on that basis, and we had an appeal, but it didn't go very far in the sense that a misdemeanor conviction at that time could be appealed to a panel of judges in the Superior Court, and so our misdemeanor conviction went to a panel of judges in Alameda County Superior Court. And there had already been one decision about one of the defendants was a juvenile and had gone to juvenile and had gone through and been convicted, and then there had been hearings about that, and there had been an order written about that validated the convictions, and basically the same thing happened with the Superior Court. And your next step is certiorari to the U.S. Supreme Court, who didn't take the case. And so it ended at the appellate level.
650 convictions.
Right.
What kinds of punishment?
Some people were given, the leaders were given some time in the county jail, mostly fines for the rest of the people, probation. So there were punishments at that level. Not a lot of people went to jail, but maybe 6 to 10.
You also were involved in some of the Patty Hearst trials.
Well, this is when I became the DA in 1969, and then I didn't try anything particularly after that, except for the Symbionese Liberation Army. When they surfaced, first thing that happened was they shot and killed the superintendent of schools, Marcus Foster, in Oakland, and shot and wounded his deputy as they were going out. And so we had that case. We had really the assassination of the superintendent of schools, and we had an investigation, but what happened was, this was in 73, I believe it was, 74, at the beginning of the year, there was a stop of a car at night in Concord, and it turned out that this was the Symbionese Liberation Army with a safe house out there, and these two people were coming back to the safe house, and they got stopped for traffic, and had a shootout with the police there, and two of them were arrested at that point. And they were ultimately charged with the murders of Marcus Foster. The other people, when they heard about what had happened and the arrest had taken place, they set their house on fire and left. But that fire got put out, and we got an enormous amount of evidence out of the house, which made it possible to prosecute the case. But ultimately, that case, I tried it, and it was in Sacramento by a change of venue.
You were district attorney, but you tried it anyway.
I tried the case, right. That is sort of a way in which Alameda County, the district attorney, had done that. And this started with Earl Warren. When Earl Warren was the district attorney, he tried several cases. Frank Coakley tried cases, including the Burton Abbott case I was telling you about. And so I tried this case. And it's an interesting time because you're in trial, and then you got to run the office too.
Mm-hmm. By that time, when you were DA, how many attorneys were in the office?
Then it started going. In the 70s, there was a big explosion of crime, and we had a sort of arrangement with the Board of Supervisors that as we needed a new court, we would get new lawyers, and we went up. We needed new courts, and our staff went up. By then, the county counsel's office had come in, and so they were gone, and we had only criminal lawyers.
You didn't have civil cases?
We didn't have civil cases at that point because they had gone off a couple years before I became the district attorney. But then we added on, and so by the time I left, there was about 100, just over 100 lawyers in the
It was still in the single building, though, in Oakland?
No. We were spread out all over the county.
Were you by that time?
No, the big building in Oakland was for for felonies, and it was only a single building where they tried felonies for the whole county. But there were municipal courthouses in Oakland, and in Berkeley, and in Alameda, and San Leandro, and in Fremont, and Livermore. So we had offices all over around the county. But one major building, the county courthouse, where the felonies were tried.
You liked being a DA. What caused you to leave that wonderful, wonderful job?
Well, a couple things. One is that I had been the DA for about 12 years. And at some point, you really are treading water, and I'm not really being very productive for the place. I mean, I've done as much as I can think about what doing, and so you really ought to move on. And it turned out it was sort of fortunate in the sense that I had an opportunity to move on when Ronald Reagan was elected president, and they were getting people to come back to the Department of Justice, and I got a chance to go back and be the head of the criminal division. So I moved from the DA's office and went back there.
Now, head of the criminal division, Washington, D.C., that sounds like more administration and management.
No trials.
Anything else.
No trials. Just basically policy.
Yeah. What do you do in terms of policy?
Well, we had maybe one change of policy was with reference to the basic laws, like the Crime Control Act of 1984 is a big act as far as the criminal world is concerned, federal criminal world. That's where they changed the sentencing laws, and we changed the bail laws, and we changed the McNaughton law, or restored McNaughton. That happened in 84. So that's a big part of this process, is that policy in terms of legislation. And that was the big effort as far as that's concerned. Other policy things we did were to, in effect, make the federal presence more a part of local law enforcement. We set up councils in every district of the country and had the local AUSAs and the U.S. Attorney get together with the DA and the local police and the federal and law enforcement agencies and had a council and basically said, what is it that the federal judge, the federal system can do that would help? And the basic answer then was, and probably still is, to help us in terms of drug prosecutions. Because drug prosecutions end up on the streets in the big cities, and but they come from all over the world, and so the ability of local law enforcement is limited to get at that. And so bringing in the federal law enforcement brings in the whole international structure and the whole interstate structure. So that's what we did. And in terms of a policy thing, make a focus on drug enforcement. We created drug enforcement task forces that still exist.
Your experience had all been stateside
Yes,
before
it had.
then. Did you bring advisors with you? Who did you lean on to become an expert on federal policy and federal criminal practice?
They're courtrooms,
Yeah.
and they're not that different. There's judges and there's legal rules that, there's different terminologies or different approaches, but it isn't really fundamentally that different. So it isn't as though you're going from a different world. I didn't come from a world of trying tort cases. So I'd been involved in criminal prosecutions all the way. So it isn't that much of a change. So, and then you have an awful lot of support. There's an enormous amount of support staff, career people who are in the Department of Justice, say, who are there as administrations change. And they provide the support and the mechanisms for learning that you need. So I didn't have a great deal of problem in terms of making a transition as far as that's concerned, because I'd both been in a courtroom and had some experience with administration also. So there wasn't that much of a difference.
What caused you to decide you wanted to get back and be a judge in the Northern District?
It was time to come back to California. I never did get to the point where I wanted to stay back in Washington. Actually, we stayed a little longer than we had thought, because I was in the criminal division first couple of years, and then there was a change in the leadership, and I became what they called the Associate Attorney General, that was over the law enforcement activities. And then William French Smith left, and Ed Meese came in as the Attorney General, and he asked me to stay, and so I stayed as the Deputy Attorney General until I could get back to California. Mm-hmm. And so I came back, and was fortunate enough to be able to come back in the Northern District. So came back in '86.
You came back to the Northern District. I don't remember too much publicity about your confirmation hearing.
It wasn't. I don't think it was a controversial event or one that would have an awful lot of attention paid to it. But we had a regular sort of opportunity. Now, I had a little difficulty back in Washington getting through on the timing, but that got taken care of. But once that got through, it was no problem.
When you came back, when you became a federal judge, you were only in San Francisco then, wasn't it?
That's right.
Who were the other judges that were there that you worked with at that time?
Judge Peckham was the chief, Bob Schnocky, Lloyd Burke, Stanley Weigel, they were the Spencer Williams down at, they had a San Jose division that had come along about that time, and so Spencer Williams and Bob Peckham and Bill Ingram were down there, and then there was the San Francisco group that I spoke of, and there was also, Marilyn Patel was there and Thelton Henderson. They had so. That was the group that I came back to, and I worked in San Francisco.
Yeah, as a new judge?
As a brand new judge, right.
I know you were certainly a collegial type with the other judges there. Did you talk to any of them about being a federal judge, what you do?
No, we have a wonderful system where we bring judges in, and there's no guarantee at all they know what they're doing. Our process is not the same. The rest of the world trains people to be judges, and they put them in there, and they're ready to go. Our system, they come through a political process, and you come in, and there you are. You're the judge. On the job training. Right, and here I am. I'm a federal judge. I've never been in the federal court, except as a defendant when they get sued once in a while as a district attorney. And my only background had been in criminal law, and so I'm given the calendar with everything, the whole federal jurisdiction, and it's a very sharp, steep learning curve. But fortunately, the lawyers are good; they teach you, and so you learn as you go along. I think the first jury trial I had was a patent case. And
You'd not had a patent case before.
I didn't know what patent law was. So you start from scratch. And there's but you can learn it. It's a real effort. But it is on-the-job training. And the people who were my colleagues were wonderful. They're very supportive, very helpful. Anything you needed, they'll get you. There's a level of academic training that they give you back in Washington for a couple of weeks, but it doesn't really get you into specifics. So you learn on the job, and our system works really quite well for the fact that you bring in people from various backgrounds who suddenly are thrust upon new areas of the law that they have to learn, and they do. You get a lawyer who comes from a nice practice in a law firm, say in San Francisco. He comes and sits, he or she comes in as the judge, and all of a sudden they're trying criminal cases. They've never been in criminal court. They never sentenced anybody. They never watched a sentence, but they have to learn that too. So our system requires that of new judges when they come in, but it works remarkably well.
Because it's been written up in so many of your profiles that are in the legal rags, I'm going to ask you about the Franklin case. It got lots of publicity. A state court case that was tried on repressed memory. Right. First time that had happened, supposedly, according to the news media, and then it comes to you. Tell me about that.
Okay. It comes to me on habeas corpus. I had gone through the California courts, San Mateo County, and been tried in the Superior Court, convicted, went on appeal to the Court of Appeal. It wasn't a capital case, and so it didn't go to the California Supreme Court, but went to the California Court of Appeal. And they affirmed the conviction. And then after you run through to the point where it's final, then you can come and there's collateral attack by way of writ of habeas corpus. So I had that case. Now, I tried lots of murder cases. So murder was not an area that I was unaware of. I mean, I had been through this process before, and the question was really whether or not there was some trial error. I mean, there's some talk about the repressed memory, but I didn't rule that you couldn't have repressed memory. I mean, that wasn't the issue. You were allowed under the law to have testimony from someone who indicated that they had repressed something, and then it came back to them, and they could then relate it. And that's what had happened in this case. The young woman, by way of repressed memory, said that she'd witnessed a murder committed by her father.
20 years before?
Yeah, there's something like that. Yeah. And so she testified to that. And the real issue, from my standpoint, was were there errors in the case, and were they prejudicial errors? And there was at least one error that was admitted all the way through, is that there had been a part of the case where the daughter had gone back and visited her father in prison, and it started to ask him about the case. And it was in one of these signs where there's a sign up there saying, these conversations are allowed. The father said, I don't want to talk about it. And so the trial allowed the fact that he didn't talk about it as being evidence of guilt, which is a basic constitutional error, which should not have been allowed. The jury was instructed, and the prosecution argued that this proves guilt, the failure to make a statement under those circumstances. And that was an error, but the California court had said they believed it to be harmful. From my perspective, that is about as prejudicial as you could have. You have a situation where the witness is testifying, and the fundamental issue is whether or not there's any corroboration to that testimony. I mean, whenever you have a situation, any time where you have personal recollection as the basis of testimony, corroboration is a major issue, and it certainly was here. And so if you were allowed that powerful of a corroboration, then it would appear to me that that's a prejudicial circumstance, and that it should not be deemed to be harmful. There was one other area of the area of corroboration where the trial court told the prosecutor, or at the prosecutor's objection, the defense was not allowed to put on newspaper articles that had details about what had happened when this homicide had taken place. And then there was argument in the case that the recollection had to be based upon personal recollection, because how else would people know these details, that sort of thing. Well, there had been stories in the papers about this, but they were not allowed to be introduced. So to my way of looking at it, it's a very specific error to not permit the defense to show that there is a basis for the testimony that the witness could have other than being present at the murder scene. That also is corroboration, the issue. So my sense was that there had been prejudicial error, and it was not harmful, and it ought to be reversed. So it wasn't really repressed memory as much as it was a circumstance where the memory that was the basis for the prosecution basically cried out for corroboration, and it wasn't there.
That's a criminal case. You had another kind of high visibility, and I don't know whether to call it a civil or criminal case, an extradition case early on in your career that got a lot of publicity.
So that was one of the generals from Argentina who had been in charge really of the whole area of Buenos Aires, and this was a part of the so-called dirty war where there were kidnappings and people were killed, and he was charged with murder in the regime that was then in control in Argentina, and they had an extradition for him. So the question was simply, it was a straightforward extradition based upon the treaties between the U.S. and Argentina, and whether or not they'd made a showing that this was the person and who was he charged and was there a basis for it. So we had hearing, and there was
testimony by witnesses, or all right?
These were all submissions from the government of Argentina presented through the U.S. and representation of them, and the question is whether or not there was enough basis to now have personal liability on his part for the murder charges, which I thought was very clear. So I ordered his extradition.
In one of the legal rags, you are quoted as saying that you haven't had any cutting-edge civil cases like Napster. I'm going to ask you about one that involved the fiduciary duty of venture capitalists, the Daisy case. Now, that was kind of a cutting-edge case, wasn't it?
I don't think it was in terms of breakthrough kind of concepts of law. I don't think so. That's why I said cutting edges to me, where you're on areas where the law is being developed, and those are cases where either the law was developed. Some other people might have a different view of the manner in which it had been developed, but so I ruled on the basis of what I believe to be developed law.
Let me ask one further question. What do you think the most important case that you tried while you've been on the federal bench was?
Maybe Franklin. I mean, in terms of if you measure impact, in terms of you have a circumstance where you have an impact upon your overturning a murder conviction in a state, and this whole business of the habeas corpus is kind of a remarkable power where a single federal judge has that authority and that responsibility to do. But it's an important part of our system. There's no question about that, and it's a very significant kind of ruling. I thought that was an important case as far as those that were given to me in terms of the exercise of authority that I'm supposed to use, and I think that was one that I remember.
I think that when we get to taking your audio oral history, we're going to go into a lot more of these cases with more detail. But I want to thank you very much for being with us today.
Well, I think this is a lovely setting. Yeah. I can't think of a better way of doing this, I'll have to tell you that.
We've arranged it specially.
Well, thank you very much.
Thanks again, Lowell.
Sure.